Happy Wednesday. Welcome back. So, the U.S. Department of Labor's Wage and Hour Division recently issued four opinion letters, and today we would like to discuss one that seems to be the most relevant. And Irene actually has worked on the case and will share some insights with us, and we hope that it's going to help many listeners. So, Irene, please share with us.
Of course, thank you, Jane. So, absolutely. So, we'll probably go into a couple of the other opinion letters that we've received from the Department of Labor in some future podcasts we do. But this one is the most relevant I found for my current clients, those that are either in active litigation or those that are restructuring policies. So, ahead of 2026 we typically talk about any changes that need to be made. And this is a big consideration that this opinion letter has brought up for conversation points in preparation for the new year. And the opinion letter addresses when two related businesses, business entities, could possibly be considered joint employers under the FLSA. And it goes further to clarify when that's the case. We did depend previously on a lot of case research and precedent to plug in some of that information. But the DOL made it very clear in this opinion letter that if there's any common ownership, any common management operations, there could potentially be this joint employer liability if one of the entities has any control over another where there are joint employees. Uh, so, an example of where this may come up is one, let's say there's one individual who owns 20% of one business, 50% of another business. And it's an active partner who's active in the business and so therefore knows a lot of the employees very well. So at any point in time, if they ever need coverage between one business and the other, especially if they're related, but they do not have to be related industries, they may ask for some coverage from the employees to cover another place. Well, that may create that joint employer liability. That means that not only could you bring in another entity if one of the entities had any wrongdoing when it comes to that specific employee, but also a lot of business owners would try to, another example, would try to open up two entities to avoid overtime. And so you would have one employee working as if in two entities and split, let's say, a 60-hour week, 30 and 30 over two entities. This opinion letter further clarifies that it would just be considered this joint employer relationship. And so the effort behind this attempt, even if there was some case law and some precedent that we could possibly put forward in defense of the business if there was any lawsuit brought based on uh, the fact that let's say we were arguing that there is not overtime or the employee is not eligible for overtime, this Department of Labor opinion letter would, at this point, really take away any defense that we have. So it's really important to make sure that in both situations where either the businesses are unrelated, different industries, or they are related, but any employment relationships are being shared between the two, or whether it's purposeful, strategic breaking down of multiple entities and sharing employees between those multiple entities. Some companies that, for example, what comes to mind is some different locations of, let's say, an urgent care or even a franchise that may have different entities, but a common goal or common ownership at the top. They may be affected very much now by this new Department of Labor opinion. So I'm adding this to our checklist for all of my clients for going into 2026, what we're reviewing, and definitely something that before we go into some of the other updates for 2026, as well as going over some of the other opinion letters, we wanted to start with this one because it does affect uh, a lot of the employment strategy and a lot of the employment decisions being made between entities and by the business owners. So, as always, if there are any questions on the effects that this could have on the business or future planning going into the new year or immediate planning, because this does take immediate effect. I know I've been talking about going into 2026, but this takes immediate effect. So there's no need to wait. We're just reassessing this now for for everybody to make sure everyone is compliant. But this is definitely a consideration that needs to be immediately addressed. So if there are any questions on how to structure the business and the employment classifications and so on between multiple entities, please feel free to reach out to either Jane or I, and we're always happy to help. Thank you so much,
Thank you.
everyone.